Judiciary Committee. We have sign-up sheets up here for the bills that are on the agenda today. If you have not signed up and you want to be heard, please come up and sign up for the sheet for the bill you want to be heard on. Senator, how are you?
I'm good.
Good.
Mr. Chairman.
I'm going to ask Senator Hatchett if he'll please open us up with a word of prayer. You are 5.
Let us pray. Dear Heavenly Father, thank you for bringing us here safely today. Please be with our families and all our constituents that we represent. Please help us to do your will in this committee today. In Jesus' name I pray. Amen.
Thank you. All right, we have 3 bills on the agenda today. We'll start and go down the list with Senate Bill 439. Senator Tippins, if you want to come up. And we are working off LC 490732, the original bill. Is that what you have?
Yes, sir, that's correct.
All right, Senator, the floor is yours.
Okay. Thank you, Mr. Chairman, members of the committee. This bill has a very, very narrow focus. It has to do with the filing for eviction by a landowner for the tenant, for evicting tenants. The law in Georgia is very, very clear about the steps that have to be gone through. The problem in the existing law is if you look at 44-7-50 in terms, and this is not in your bill, but in the terms of that section of the law, it says the owner or the agent, an attorney at law or an attorney in fact of such owner may immediately go before the judge of the Superior Court. It says all these other things but that's filing for the eviction. But when you actually go before the judge to hear it, that is a section that we're dealing with today, 44-7-53, Section B. If the tenant answers, a trial of the issue shall be had in accordance with the procedure prescribed for civil actions. If the tenant for civil actions in courts of record, except that if the action is tried in the magistrate court, the trial should be had in accordance with the procedures prescribed for that court. And that's where the conflict arises. Under the Uniform Court Rule 31 for magistrate court, it says any officer or full-time employee of a corporation, sole proprietorship, partnership, or unincorporated association may be designated for such entity as an agent. I have 4 different legal entities that I own property under. A few of them are titled in my own name. And on a tenant eviction of all the other the other LLCs or corporations, I can appoint someone who's not an attorney, but as an agent to represent me in that action. But I've been told by a particular court that I cannot appoint an agent for something that I personally own, and I have to personally appear for the trial if it has to go before a hearing of the judge. I brought this up 2-3 years ago to try to clarify it. They gave me this code section and said if they tell you that you can't hear it, show them this code section. And I did that, and they said yes, but the magistrate court rule governs in that, Rule 31. Now, I'm not a lawyer, but I did study law, and there's very little difference between a sole proprietorship and an owner, because most of the time you have an owner doing business as if it's a sole proprietorship. But if you can trust Wikipedia, it says it really doesn't make any difference. They can operate a person can operate under their own name or have a name, a business name that they adopt. My problem is I have to appear for any property that's titled in my name. But if it's an LLC, I can appoint an agent who's not an attorney. It can be an attorney in fact. And that needs to be clarified so the magistrate court rule can be clarified. And it's an imposition. If you have older property owners that may not be able to go to court, they cannot appoint the person who may be looking after their property to represent them in this issue. And I'm asking that the law be changed on line 15, not be changed, but just clarify, saying that provided, however, that in any such trial, the owner of the land or tenement at issue may appear individually or by agent or attorney in fact or attorney at law. And this applies in this code section only to the magistrate courts. So I ask you to make that minor change, approve that minor change in the law. I think it's probably the intention of the existing law, but it's not clarified. And I personally think it's probably being misinterpreted, but I'd like to clarify that. So that's my ask.
So under my understanding, existing law, when you look at a magistrate court where these type of hearings initially take place, and any individual, whether that be a landlord or tenant or civil plaintiff or defendant, if they're not an entity, they have to appear now. My understanding is in person for these matters. Do you know? Are you aware of that?
Not if you're sole proprietorship, because
right.
that particularly gives you that ability to do that, which
right.
can be an individual who may or may not even have any employees working for them.
Right. If you're sole proprietorship, but otherwise individuals have to appear.
Only an individual has to appear. But they told me in this particular court, they said if you just retitle it in another name, it's some kind of, you're doing business as, you can appoint an agent. I really don't see the benefit of that, of having to go through the process of changing deeds and recordings. It looks to me like the intent would be, since the magistrate court is a people's court and it's probably the first jurisdiction in these kind of issues, that you could appoint someone. I mean, I can tell you in my position, in my situation, my son looks after my property. He knows a whole lot more about it than I do, yet I have to appear, but he's the one giving the testimony. So,
well, I guess my question, though, is more of why should it just apply, or should it just apply for a property owner in a dispossessory? Should the rule where any individual can send someone their place apply to all types of cases, and should it apply to tenants, for example, in a dispossessory as well?
Well, I really haven't had experience in those other issues. Most of y'all are practicing attorneys, and you know more about the ramifications of the law. But as it has affected me, it looks to me like this is a problem in law, maybe by just lack of clarity.
And maybe someone's going to testify that someone brought up the fact that, I think your intent here is just to deal with magistrate court. You just said that, but one of these cases can be appealed to a state or superior court. Is it your intention to make that same rule apply to state or superior court, or just to the magistrate court itself?
Well, there again, I think there may be a little bit of misunderstanding in the definitions. I think somewhere in here it references a court of record.
Right. And that would be the other courts.
That would be in 44-7-50. Where the owner or agent, attorney at law, or attorney in fact of such owner may immediately go before the judge of the superior court, the judge of the state court, or the clerk or deputy clerk of either court, or the judge of the clerk or deputy clerk of the other court with jurisdiction over subject matter, or a magistrate court in the district where the land lies, and make an affidavit under oath to the facts. But the part that's really in question is the language in 44-7-53 that says in accordance with the procedures prescribed for that court. I'm not sure that you can appoint an agent to go before the other courts, but it's the rule 31 of the magistrate court that's a preclusion for being able to do in magistrate court what it appears to me that the law would allow in a superior court or a state court. But most eviction proceedings take place in a magistrate court because there's a great deal of difference in the fees charged for processing these. If you go back and look at the history of this and you do some research on it, you may see why that happened to be the situation, why this language may be there to start with.
Yeah, it seems crazy to me that an individual should be able to have their day in court, make their case out. If they can't do it because the right person's not there, that's a different story. But if you got a judge saying, no, you can't file this, you can't appear because you're here, it doesn't make a lot of sense to me.
Well, you can file it. I can have an agent file the action.
But they won't give you a trial.
They won't give you a trial. You have to come back for a trial. But when you have to come back for a trial, then you have to appear yourself if you're an individual. But if I happen to be Lindsey Tippins operating as Tippins Lindsey, I could appoint somebody else, which is nonsensical to me.
You have another question, Senator Kirkpatrick?
I'm a little confused because the summary that we have indicates that this is already in the uniform rules of the magistrate court?
Yes, ma'am.
Yeah.
And the preclusion is in the magistrate court, but what would happen is this clarification in statute law would, the rules of magistrate court would be brought into line with statute law from a clarity standpoint. Because, I mean, if you go back to the previous, not the previous, but 44-750, that's the one that gives you the ability to appoint an agent in any of the courts. But only in 44-753, let me make sure I'm telling you right. It's where you have the language of it has to be in accordance with the procedures prescribed for that court. It looks to me like the procedures prescribed for magistrate court are more restrictive under current practice than it is for state court or superior court.
Any other questions from the committee at this time? All right, I have a couple people that signed up to speak. I forgot to recognize our judges of the day. Judge Bill Hamrick from Coweta County. Is Judge Hamrick? There you are. I didn't see you. Thank you for joining us. And then Judge Burt Guy from down in Brunswick once again. Are you having any court down there? You're up here all the time now. Okay. Thanks.
Citizen, we really worry about him being.
Right. Right.
You know how it goes. Most of the lobbyists have a house in my district now.
No, I know, that's right. Well, good to have you up here again, both of y'all up here today. Let's see, we have Lindsey Siegel, Director of Housing Advocacy, Atlanta Legal Aid Society. Hey, good afternoon.
Good afternoon. Thank you, Mr. Chairman and members of the committee. My name is Lindsey Siegel, and as you said, I'm the Director of Housing Advocacy at the Atlanta Legal Aid Society. Just to give you a little bit of context on our background and why we care about this bill, Atlanta Legal Aid is a nonprofit organization that since 1924 has provided free legal aid to low-income individuals across Metro Atlanta. We handle about 20,000 cases every year. And in those, some of those are representing tenants in each of the dispossessory courts in the 5 metro counties. And our goals are to help families maintain the homes they have and ensure that those homes are safe and affordable regardless of a family's income. So as you probably know, the vast majority of landlords are represented by attorneys in an eviction case, and the vast majority of tenants do not have a lawyer to represent them. And given that there are not enough, unfortunately, legal aid lawyers to represent every tenant, our interest really is in ensuring that the court procedures and the practices, at a minimum, give both sides a fair shot at advocating their position, and they don't favor one side over the other. So we do have concerns about the language in SB 439 as written, and those concerns fall into 3 categories. First, in the language of the bill, where it refers to any such trial, and this is the question, Chairman, that you were bringing up, I don't think that it's clear that it's limited to magistrate court. Second, if landlords are allowed to have agents representing them, tenants should also have that same right, as you pointed out. And third, the current magistrate court rule does impose some limits on agents that this bill doesn't seem to contain. So I'll first talk about the application. I don't think that it's the sponsor's intention that it apply to courts of record, but the language really isn't clear, and we would have some real concerns about non-lawyers representing anyone in a court of record, because of course they don't necessarily have any legal training. They're not bound by the same ethical and professional requirements as a lawyer. I don't have the statute that the sponsor was referencing, but I don't believe that agents can currently represent an individual landlord in state or superior court or in any court of record. So I think that language should be clarified in the bill by adding the words "before the magistrate court" after the phrase "in any such trial." So to the second issue, tenants really do have significant barriers to appearing in court. The vast majority of these cases where a tenant has filed an answer and they get a hearing, the tenant doesn't show, and the landlord wins by default. Low-income tenants who we represent often have to choose between going to court and going to their job. And most do have jobs that don't give them the flexibility to take off for court. They also commonly have childcare issues. And tenants who are elderly or have disabilities or illnesses have a difficult time appearing, either in person or even to navigate the virtual hearings. What happens, practically speaking, is that some tenants do send a family member or a friend to court on their behalf when they can't come themselves. And when that happens, a tenant loses by default, just as if they didn't appear, and the writ of possession is issued immediately. If the committee is inclined to vote in favor of the bill, we suggest adding that tenants can also be represented by agents, because tenants should have equal access to the process. And third, the current rule, the Magistrate Rule 31 that the sponsor referenced, it allows only a corporation to designate an agent who's a full-time officer or an employee to represent that corporation in magistrate court. And again, practically speaking, what happens in our magistrate courts, at least in DeKalb County, where I most often practice, is they have a form that agent fills out. And again, they have to be designated by somebody who is an officer, and they have to be a full-time employee. That form is notarized, and it's filed with the court in advance of the hearing. And if it's not filed in advance of the hearing, then most of the judges will reset the case to give the landlord an opportunity to file that form. But this bill doesn't have that requirement. So I'd be very concerned how courts would ensure that the person appearing actually has the authority to act on behalf of that party. So I would encourage the committee to require some sort of proof that the individual is authorized to act on the party's behalf. So really that sort of summarizes our issues with the bill, and why we would hope that if the committee is inclined to vote yes, that it be amended in those ways, and I'm happy to answer any questions.
I think you hit the nail on the head as to why I think open it up as you're suggesting wouldn't work at the end of your statement, because if someone else could just come and appear, for example, for a tenant, how is the court or the landlord to know that person actually has that authority? Are we not worried about potential abuse of that? Someone say, I'm here for them, and they negotiate a settlement, for example, a new lease or resolving money that's owed, and yet they never had that authority. How could that work?
I mean, I think they'd probably have to use the same form that they use to designate agents on behalf of corporations. I think that's the safest way to do it. I definitely have concerns that tenants won't be able to navigate that, especially because the form requires a notary. So, any barriers that are put in place are going to disadvantage tenants, certainly the ones that we represent. So, I have concerns they won't be able to utilize that process, but I think that's the safest way to guarantee that somebody is in fact authorized.
Senator Kennedy.
Thank you, Mr. Chairman. Thank you, Ms. Siegel, for your testimony. It strikes me that from experience in practicing that most dispossessories against tenants are brought about before non-payment of rent. Would you agree with that?
Yes.
Given that that's the case, and if a tenant were to be represented by an agent or someone that in essence excused their appearance, then how does the court get the testimony or evidence that's typically needed in a dispossessory matter, since the core issue is the conduct of the tenant that is in non-payment of rent?
Well, there's a couple ways they could do it. I mean, tenants who have paid their rent, so sometimes tenants have paid their rent and their landlord files for non-payment of rent anyway. It happens. I represent many of those tenants. So the agent could come with proof that the tenant has paid, a copy of a money order. They could also come with proof of the tenant's counterclaims. Many of the clients that we represent have valid counterclaims because their landlord hasn't kept the premises in good repair, for instance. So they could come with those pictures. A lot of times this person that they send, frankly, is somebody who is intimately aware of what's going on. It's a mom, it's a boyfriend who lives there but maybe isn't on the lease. It's somebody who really knows what's going on and could probably provide firsthand testimony of some of those things, like the repair issues. The other issue is for a tenant who appears in court, even if they lose that case at the end of the day, they still get 7 days before the writ of possession is issued. So there's some benefit for tenants who have an agent appear, even if that agent is unsuccessful in winning the case for them, they still get an additional week to leave. Whereas if they don't show up, or they show up with an agent who, is not, the court doesn't recognize as a person who's authorized to speak, the writ of possession issues that day, and the marshals could come out the very next day. So it gives tenants a little bit more stability and time to find another place if they are ultimately going to be evicted.
I appreciate those answers, but it really doesn't address the vast majority of dispossessories that are filed. You'd agree with that? If we're talking, I think if we agree most dispose are because of non-payment of rent, and in that event, doesn't the court really need to hear from the actual tenant, that is the person that signed the lease? They're the party in interest, they're the party that has standing, whatever title we want to put on it with legal effect. The court needs to hear from that person, not someone else that doesn't have a property interest or a possessory interest in the subject property. Wouldn't that be fair that the court hear from that person?
I mean, I think the judge could decide if certainly they need additional testimony, and they could even reset the case to ask that certain witnesses appear, but
And now we're talking about continuances, which drags it out and makes it a longer process, where if the tenant had come to start with, because they're the one that has it on the line, right? They're the one that's at risk of losing the ability to stay in their home or apartment or whatever it may be.
But that's an issue of proof, and I think if the tenant sends an agent who doesn't have the proof required to prove their case, unfortunately, that's going to be on the tenant. They could try to send whatever documents they have to try to prove that, in fact, they did pay rent or they did offer to pay during their perfect tender period, which is a legitimate defense. But you're right. Some tenants, their agents will not have enough information. But should the court say that then a landlord is able to designate somebody who also may not have that proper information and may not have firsthand testimony about whether the tenant paid or not, but not give the tenant the same opportunity to do the same thing, I think it would be unequal.
Well, I understand that, but I think to Senator Tippin's point, the reason that this legislation is wanted is it may be in many cases, and in fact maybe in most cases, that from the landlord's perspective, who is the plaintiff on the dispossessory action, they in fact don't have the most information. They don't have the hands-on working information. They've not worked in the office. They don't have the payment history of the tenant. And so sending that person that does have that information is, in fact, that's who the court needs to hear from. So thank you, Mr. Chairman.
Any other questions for Ms. Siegel? Senator Rhett.
Thank you, Mr. Chairman. Just could you sum up again your suggested amendment that you wanted so that we can be clear on it?
Sure. So the first one, there's a couple. So the first one is to add the words "before the magistrate court" after the words "in any such trial." Just to make clear that we're not talking about courts of record like state or superior court, where non-lawyers are typically not able to represent people. So that's the First Amendment. The second one would be to add that tenants can also represent that agents could also represent tenants. So it would be to add the words "either or both the tenant" after the other words that I just added. So it would read, "Provided, however, that in any such trial before the magistrate court, either or both the tenant and the owner of land or tenement at issue may appear individually or by an agent," etc. I think it's also useful to add that there's some kind of proof of designation that should be required so that we ensure that the person has the authority of either the landlord or the tenant.
Any other questions from the committee? All right, thank you.
Thank you.
Next, we have Miss Elizabeth Appling, Enterprise Community Partners, Georgia Act 9 to 5, Georgia Presbyterians for a Better Georgia. Bunch of hats. Good afternoon.
Thank you, Mr. Chairman. My name is Elizabeth Apley. I won't repeat my client list on this issue of housing stability and affordability, but I come to echo Ms. Siegel's testimony. She is an expert in doing these cases, and we appreciate Chairman Tippin's concern. I spoke with the chairman earlier today, and we do want to draw your attention to our concerns in perfecting this bill. Housing stability is critically important for families to be able to succeed. When a family is evicted and becomes homeless during the pandemic, we put the entire community health and well-being at risk. We know that homelessness is on the rise, that evictions are on the rise, and the reality is that children can't go to school remotely if they have no home, parents can't work remotely, and we know that the very foundation for families to succeed is having a stable home. So eviction is a very serious process. And we echo the recommended amendment that Ms. Siegel offered, just to make clear that I understand this is the author's intention, that the designation provision be limited to trials in magistrate court, not to appeals, and not to appearance in state or superior court. And secondly, to address the issue of tenants appearing. And of course, the right to appear on behalf of the owner, on behalf of the tenant, doesn't mean that other people can't be brought forward to testify. But we do believe that it would be equitable in this circumstance where a family's home is at risk to allow them to appear. I have from Bambi Hayes Brown, the executive director of Georgia Act, an email where she reminds me that in her former life she was a property manager who conducted hundreds of evictions in her career, and she says it was always disheartening to me that numerous renters had to choose between coming to court to fight the eviction or go to work, housing or employment. I recall many times renters asking me if their parent, a close friend, significant other, or someone intimately familiar with the housing situation could attend court in their place due to their employer's unwillingness to allow them time off work. This is very much needed and would help to level the power imbalance between renters and landlords. It was mentioned in the testimony already before the committee that if the landlord appears by an agent who's not authorized, the judge resets the proceeding. If the tenant appears by an agent not authorized, the writ issues that day. So that is a very serious imbalance at a time when housing stability is of critical importance. We also know that tenants are sometimes evicted, or the eviction proceedings are filed for reasons other than non-payment of rent.
Are you familiar with the forms that are currently used when someone designates an agent now? Okay.
I'm sorry, but Ms. Siegel certainly is, and she can
Okay.
perhaps
Let me make
better
sure
respond,
there's-
Mr. Chairman. I'm sorry.
Let me make sure there's not any questions for you first from the committee. Any questions for Ms. Appling from the committee? Senator Rep.
Thank you, Mr. Chairman. Do you have any suggestions in terms of any edits you might?
Yes. We would echo the amendment that Ms. Siegel suggested to insert on line 15 after provided, however, that insert before the magistrate court, either or both the tenant and. So what this is clarifying that the designation would apply only to a trial in magistrate court, and the secondary goal of allowing a tenant also to designate a third party to appear on their behalf in that proceeding in the trial.
I'm a little slow.
Mayor.
Wait till he gets his chair.
Here are questions from Ms. Appling from the committee. All right, thank you.
Thank you, sir.
Ms. Siegel, can I ask you one follow-up question? Mind stepping back up? I just read it. The form, so you mentioned the form that's currently filled out when someone's going to be an agent under Rule 31. Two questions on that. Is that form something that's set forth in the rules for the magistrate courts? And then regardless of what it's set forth in the rules, is that something that's signed by the individual that's granting someone the ability to be their agent? Is that how that works?
As to your first question, it's not designated specifically in the rule what this form has to look like. I just pulled up the one for DeKalb County. I think, each county may have a different form, to be honest, so I don't know that this form is specific to DeKalb, or I'm sorry, it is general. Yes, the person who is designating the agent has to sign it, and it has to be notarized.
Okay. You have a question for her? Senator Hatchett.
Yeah, thank you for being here, and I have a question about the public policy behind the rule to begin with. My understanding and if I'm remembering correctly, one of the reasons why this bill or this law was put into effect is because there could potentially be a conflict of interest between an owner of a corporation and the corporation itself when it comes to liability for various numbers of reasons. So, does this bill allowing an owner or agent to represent the company in magistrate court, does that circumvent that public policy to begin with?
To be honest, I can't really say. I don't represent corporations, and so that corporate law is not at the top of my head. So I'm not sure. I will tell you that it's, practically speaking, it's really just so officers of a corporation don't have to be there to testify, so they can send somebody. It's quite rare, actually, that there's entities that use this law, at least in the major metro counties. It may be more popular out in the rural areas, but the vast majority of landlords have representation by a lawyer. This wouldn't change that for any landlord that wanted to have a lawyer represent them. It's just for those few landlords that either, they have a sole proprietorship or something like that, and they don't want to hire a lawyer to represent them. They may have a property manager or an assistant manager who has the ledger come to court instead of them.
Okay.
I think that's what it's for.
Thank you.
Here are questions from the committee. All right, thank you for coming back up.
Yeah, you're welcome.
Senator Tippins, I'm thinking we hold on taking a vote today and look at the idea, if we're going to do this, my thought is we look at whether or not it should apply to anybody appearing in magistrate court. And if it's going to, I wonder if we ought to look at possibly codifying the form or requiring the form to be completed by whoever's using it to prevent any issues of fraud that could come up. Just a thought on it. Unless some other members of the committee have different thoughts. And I'd encourage you to get with Senator Tippins on that. Do you want to come back up?
I'll be brief.
Yes, sir.
Don't have a lot on the agenda. I'll be very brief. Two things that concern me. If you look in existing law in the code section we're dealing with, starting on line 16, it says every effort should be made by the trial court to expedite a trial of the issues. The defendant shall be allowed to remain in possession of the premises pending the final outcome of the litigation, provided, however, that at the time of his or her answer, the tenant must pay rent into the registry of the court pursuant to Code Section 44-754. The thing I'd point out, and I'd ask you to vote against the amendment as it is, because I've never been in a dispossessory proceeding that the magistrate judge did not ask you to go to arbitration. And I don't believe that any agent that comes in is going to have the ability to fulfill a specific performance that it's going to take, because, as it was pointed out, most of the time you're in a dispossessory, it's because of non-payment. I've had premises that drug on for 9 and 10 months without being paid, just because of different ramifications. Anytime we can keep a tenant and keep them concurrent, we'll do it. We don't want to get rid of people, but the thing about it is, it's if you're going to have arbitration, you've got to have someone there that has the capacity. Secondly, I'll say this: when I sent my son to the magistrate court, he had a power of attorney from me that was a notarized power of attorney to represent me in that specific case in that specific matter, and it was turned down. So, because of Magistrate Court Rule 31. That's what I'm asking you to fix, if you will. Thank you very much.
All right. Thank you, Senator Tippins.
Thank you for your time.
All right. We will move to Senate Bill 54. Senator Harbison. We are working off LC 412782.
Yes, sir. That's 412782.
Yes, sir.
Yes, sir, Mr. Chairman. Thank you, Mr. Chairman, and members of the committee. I bring before you Senate Bill 54. The short story behind this bill stems from an incident in Muskogee County whereby there was an ongoing domestic dispute, and it ended ultimately in one of the spouses killing the other, the man killing the woman. And that involved some children. And after the offender had killed his wife, he took it upon himself and had the leeway to go in and adjudicate or tell whoever was in charge that he wanted his children to be with his family. And this came out of that. The bottom line is, came out of that, trying to alleviate the situation until that could be delayed until after his trial. If the person is found not guilty, then that's another story. But if the person is guilty, then clearly that'd be another story altogether. We think that it's unfair for a person to commit a murder and have the authority or the power at the same time to say where his children will live for the rest of his life if he's going to be incarcerated. I bring to your attention also, Mr. Chairman and members of the committee, that the Georgia Commission on Family Violence is interested in this. They notified me that they're looking in this and wanted this to be looked at, and hopefully we can come to some kind of agreement whereby we can prevent that kind of thing happening before. I believe it's a very small change. It may be small, but I think it's significant. Perhaps it can bring some relief to some families or situations that may occur again in the state of Georgia.
All right. Thank you, Senator. We heard this bill a year ago,
Yes.
And at the time there was some concerns brought up about the separate termination of parental rights cases that could be flowing in a different court while you have this law here in Title 19. And I think we left it with you would get some feedback from some family law folks associated with the bar, that section of the bar. Have you got any feedback from anybody in the last year?
Actually, I lost contact with the people I've been working with. There were some changes of jobs, and the only person that I'm in contact with now is the program manager for the Georgia Commission on Family Violence.
Okay.
And if I can get them to buttress this up somewhat to, whatever we need to do to try to alleviate the situation, I'd be more than happy to do so. But I would like to bring it up and keep it up, up there in the air so people can look at what we're trying to do and understand that we haven't given up on it.
Okay, any questions from the committee for the author? All right, y'all are really quiet today. Nobody signed up to speak. Anybody going to be heard on this bill? What's the pleasure of the committee? Senator Rhett, we have a motion to pass. Senator Rhett, do we have a second? We have a second by Senator Harold. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. All right. Well, that's one way to keep the bill moving.
Thank you, sir. Thank you, Mr. Chairman.
Thank you.
I'm grateful. Thank you very much. Appreciate it.
If they got concerns, maybe next time they'll show up. All right, the last bill on the agenda is Senate Bill 395. Senator Hatchett, it may be easier just to, go down if you want. Either way, you can get prime for your next appearance. I hope it's easier in your next one. All right, we are working off LC 490737.
Yes, Mr. Chairman.
Floor is yours.
Thank you, Mr. Chairman, members of the committee. I bring today Senate Bill 395, as the chairman said, LC number 490737. What this bill would essentially do is add a third Superior Court judge to the Mountain Judicial Circuit. And to kind of explain the process behind how we got here, the Judicial Workload Assessment Committee, which is a standing committee of the Judicial Council of Georgia, has a formula to evaluate the caseload in each judicial circuit. There are 50 judicial circuits in the state of Georgia. Right now, the Mountain Judicial Circuit ranks number 3 in need. And there are 8 judicial circuits right now who presently qualify to get an additional judge. South Georgia, Blue Ridge, Mountain, Coweta, Clayton, Atlantic, Northern, and Atlanta. And right now in the governor's budget and the budgets that we're seeing, and based off of the Judicial Workload Assessment Committee's recommendation, 3 of those circuits have been given funding as the budget's written now. Obviously Mountain is one, Blue Ridge and South Georgia are the other. So this, after going through the studies, the formulas, getting in the budget, and now as long as we get this bill passed, the Mountain Judicial Circuit will have a third judge. And if there's any question, I'm happy to answer.
And it's effective January 1st of next year.
Yes.
And is that how it's funded in the budget as well?
It's actually funded in the budget to be effective July 1st, 2022, but the position won't come up until January 1 of 23. And it'll be a appointed position for a year, and then after December 31st of 2023, I believe, then there will be an election, as is typical with Superior Court judges.
Or you have a question from Senator Watson?
Yeah, just point of clarification. So this is the only one that's being proposed, or the others coming from the House, or
There are 2 in the House.
2 in the House
Yes.
for Blue Ridge and South Georgia?
Yes, South Georgia and Blue Ridge are in the House, and this one, for whatever reason, we started it in the Senate.
Just for whatever reason. I got you. Okay.
Any other questions from the committee? Senator Hatchett?
Too easy. Judge Hatchett
And Judge, the Senator, there's no one else to sign up to be heard on this bill. There were some people who signed up, but I believe everybody wanted to be heard in the next committee hearing. Is there anybody that want to be heard on this bill? All right. What's the pleasure of the committee? Oh, we do have a question.
I was going to make a motion up here.
That would be the good pleasure of the committee. Go ahead.
Okay, move to pass on LC 490737.
All right, I have a motion to pass by Senator Kirkpatrick, a second by Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It is, Senator Parent, it is unanimous. All right.
Thank you very
on
much.
to rules. That concludes our business, and we are adjourned. Yeah. I'll recognize you as the guest judge next year.